Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. Joining me on the panel for the case we will be hearing this morning are Justice Mary Sullivan and Justice Vicki Henry. We are hearing only a single case this morning. This was a case originally scheduled to have been argued on January 6th, and it was postponed and rescheduled to today's date. We are hearing this case via our Zoom video platform, and that is in recognition of the continuing threat of the pandemic. We hope at some point in the not too distant future to return to the John Adams Courthouse, but we are indebted to our dedicated staff for their assistance in making it possible for us to continue conducting operations and conducting these hearings using the Zoom video platform. Before I call the case, I just want to mention for anyone who is watching, and of course for counsel who are participating, by virtue of the fact that we are as members of the panel participating in this hearing, watching all of you and each other on the Zoom video conference screen, we are of necessity consulting other screens, in my case, my iPad, for reference to the case materials, the briefs and other record materials. And if I glance away from the screen, and I know I speak for my colleagues in saying the same thing, if any of us glances away from the screen for the purpose of doing that, it is for that purpose and not to conduct other activities or distractions. We hope and expect that we will proceed through this hearing without any technical difficulties. We have encountered them on occasion in the past, whether due to internet issues or power outages, you name it. But we've developed a fairly well developed bag of tricks to work our way through. We just ask that you be patient with us if we have the need to troubleshoot. With all of that background, the case that we will be hearing this morning is case number 2021 P264, Stephen Marola versus Joseph Catalda and others. Ms. Silva, you may begin.
Thank you. Good morning, and may it please the court. My name is Susan Silva, and I'm arguing on behalf of the defendants. This is defendant's appeal of the partial denial of defendant's special motion to dismiss. The plaintiff, Stephen Marola, filed his lawsuit against 6 defendants who are either opposing parties, opposing counsel, or an expert forensic accountant in 2 prior litigations against him and his companies. Marola complains that the defendants are liable to him for obtaining and using certain bank records in violation of an ex parte discovery order in a case filed by defendant Coco's company against Marola and his companies, and then using those bank records in a second litigation filed by defendant Vilma Cataldo against Mr. Marola. The ex parte discovery order in the OCV case applied to the sole defendant in that case at the time, a company called Metropolitan Capital LLC. Mr. Marola complains about records of an entirely different company, a company called Metropolitan Capital Income Fund 1 LLC. Those bank records were obtained in the OCV case pursuant to a subpoena with notice to all parties, including Mr. Marola. Then they were obtained a separate time in the Vilma Cataldo case, again with notice to all parties, including Mr. Marola. There was no violation of the OCV discovery order as a matter of law. However, even if there was, the defendant's interpretation and understanding of the OCV discovery order and all that flowed from it, including compliance or non-compliance with the order, is all petitioning activity, and claims based on that conduct is prohibited by the anti-SLAPP statute. The only issue on appeal is whether the alleged violation of the OCV discovery order is petitioning activity under the anti-SLAPP statute.
Ms. Silva, you're familiar, I'm quite sure, with the memorandum of decision by the motion judge, and he made the observation. He referenced 2 distinct, separate analyses. The first, of course, and I'm sure we'll get to this, was that he compared the the discovery order to the non-disclosure agreement in the Duracraft case. But separate and apart from that, he suggested that your argument would preclude actions for contempt claiming violation of a court order. How do you respond to that latter observation?
Your Honor, I disagree with that observation. Contempt complaints are generally filed in the litigation where the contempt occurred. In this case, we're not suggesting that Mr. Marola didn't have a remedy available. We're suggesting that the remedy was either in the OCV case or in the Vilma Cataldo case. And what the anti-SLAPP statute does is it protects the parties against allegations like this in a separate lawsuit that their conduct, their petitioning activity subjects them to liability. And it's the allegations that we have to really look at for purposes of determining the anti-SLAPP statute. And Your Honor, I would like to address, if it's okay, your reference to the Duracraft case, which you're right, the lower court relied on to say, carve out a very small piece that the intentional infliction of emotional distress claim would not be dismissed under the anti-SLAPP statute, comparing the OCV discovery order to the non-disclosure agreement in Duracraft. But Duracraft involved a private non-disclosure, non-compete agreement that had been negotiated between two parties outside of the context of any litigation. It wasn't filed in court at the time or otherwise for approval. The Duracraft court held that the suit by Duracraft for breach of that non-disclosure agreement did not implicate the anti-SLAPP statute because the defendant, former employee, had waived his otherwise valid right to petition by signing that pre-existing independent contract. Now, our case, we're dealing with the OCV discovery order, which arose and only could have arisen in the context of ongoing litigation. And you'll see in the papers, it's our position that the OCV discovery order is unlike the non-disclosure agreement in Duracraft, and it's more like the agreement for judgment in 477 Harrison Ave, which is a 2019 SJC case that distinguishes Duracraft on facts very similar to our own.
Well, and it seems to me that it's different from both of those in one important respect, and that is that it didn't rest on an agreement between the parties at all.
Exactly, Your Honor. It arose and only could have arisen in the context of ongoing litigation, which brings it even more so under the realm of the anti-SLAPP statute. But the reason we cite to 477 Harrison is because it did a good job of distinguishing Duracraft and saying that the difference there was that the agreement for judgment was negotiated in the context of litigation, filed with the court, they asked the court for relief, and an order entered in accordance with its terms.
But here's the thing that I mean, you're quite right that the order itself is entirely derivative of the litigation. However, it's not the order that we're looking at so much as the acts by the defendants that form the basis of this suit. And if you're familiar with the history of the 477 Harrison litigation, the case that you quoted in your brief was the second time that case came before the SJC. In the first of those visits, the SJC traced the history of abusive process litigation, among other things, and observed that misconduct rather, within the context of litigation is and remains actionable despite the anti-SLAPP statute. You need to reconcile those two strains, don't you?
I think that the second 477 Harrison Ave case does reconcile those two things. And it focuses on the fact that what the parties were accused of violating was a court order. It was the agreement for judgment, which was entered as a court order. And that the abutters in that case who had a counterclaim for breach of that agreement, they had remedies available, but it wasn't a remedy in a separate action because that implicated the anti-SLAPP statute.
Isn't it important that the actions that they undertook allegedly in violation of the court order were themselves petitioning activities? In other words, the court order, the agreement for judgment, waived recourse to further petitioning.
I think, Your Honor, what's important for the 477 Harrison case was that, and what they tried to focus on in that case was that the agreement for judgment had been negotiated between the parties, and that's where they tried to draw the comparison with Duracraft. But once it entered as an agreement for judgment, it ceased to exist as an independent agreement, and that's really what the court focused on.
But it's not it's not the underlying order or agreement so much as the nature of the conduct and whether that conduct is protected petitioning activity within the meaning of the anti-SLAPP statute.
Sure, Your Honor. And in all litigation activity is a petitioning activity, and there's case law on that I can cite where conduct in litigation, including conduct by counsel, is all considered petitioning activity under the anti-SLAPP statute. So it's our position that the lower court judge, correctly found that much of the conduct complained of, including the claims for fraud and defamation, including the providing of the bank records for use in the Vilma Cataldo case, the court correctly found that all of that was petitioning activity, but where the court erred was in misapplying Duracraft. Because the defendant's interpretation and understanding of the OCD discovery order and all that flows from it, including compliance or non-compliance with that order, is all petitioning activity. The claim for intentional infliction of emotional distress also should have been dismissed under the anti-SLAPP statute. And if there are no other—
So counsel, it seemed like one of the arguments in your side's briefs was that the records that were disclosed were of a particular corporate entity, and that they weren't covered by the order. But the judge said, well, you're trying to pierce the corporate veil, so you can't have it both ways. You can't claim in one instance that it's a separate entity and then claim in the rest of the litigation, oh, we can pierce the corporate veil. What do you say to that?
Your Honor, can I provide an answer? I see my time's coming.
Yes, you may.
Thank you. Your Honor, I think that the lower court judge, what they said was that there were some gaps in our proof on whether or not there was a violation of the court order. And where I would direct your attention is to two documents. First is the OCV docket, and second is to the affidavit of Matthew Caffrey. Those documents outline the timeline, and the ex parte order entered at a time when there was only one defendant in the case. 2 months later, after Mr. Marola and his companies had been served with complaints, another entity was added, Metropolitan Capital Income Fund 1 LLC, and a separate subpoena went out with notice to all parties. Mr. Marola didn't move to quash that subpoena, although he had an opportunity to do so. In the Vilma Cataldo case, a separate subpoena went out for the records of Metropolitan Capital Income Fund 1 LLC, and Mr. Marola concedes that, and he says that in paragraph 27 of his complaint. And it's actually those records that were used to obtain summary judgment, which is much of the damage that Mr. Marola complains of.
Right. Thank you.
Thank you.
Mr. Grossbaum.
May it please the court. My name is David Grossbaum, and I represent Samar Obaid and Matthew Caffrey. I wanted to start by addressing Judge Green's question about the contempt proceeding. If you look at Massachusetts Rule of Civil Procedure 65.3, it actually precludes a separate contempt complaint for any claims cognizable under rules at least 26 and 37, which are, of course, the discovery rules that would govern establishment of and violation of a discovery order. So the means that the trial judge in the underlying cases had at his or her disposal would have been those rules 26 and 37, certainly would have been what I believe would be the judge's ability to impose contempt without a contempt complaint if a party to the litigation violated a specific order of the court. And of course, the rules of professional conduct could be employed. So
counsel, let's assume this wasn't bank records, but it was something much more intimate, like a diary or an intimate photo, and a party then disclosed that photo to the internet in violation of the discovery order. Are you saying the remedy would only be within the litigation and as a contempt sanction? You're saying there wouldn't be an independent cause of action?
Well, I think that is what I am saying, Your Honor. And I guess we can certainly distinguish that hypothetical from this one, because all of the conduct that is complained of all occurred in litigation. No one says, not even Mr. Marola says, that the use of the records was ever used in a fashion unrelated to one of the two litigations. So your question's an interesting one, and I guess I would say if it involves the petitioning activity, but I guess, Your Honor, in that sense, right, we might say that the person has gone beyond the petitioning activity. So
that's precisely the point, isn't it? I mean,
Yeah.
this is this type of intentional infliction of emotional distress is like abusive process and alleged misuse of the litigation process to achieve an improper end.
But it all
Much like
occurred-
Judge Henry's example.
Well, I guess the reason I think Judge Henry's example is quite different than this case, Your Honor, is again because all of the conduct that's complained of occurred in litigation. The conduct of my clients, as well as all the other clients, occurred only to foster the litigation. It wasn't used outside the litigation, and therefore, discovery is certainly the largest part of litigation. Litigation is clearly petitioning activity. If you chill discovery, you chill litigation, you chill petitioning. I mean, if parties have to face, I see that my time is up. May I just finish the thought?
Yes, although I think I know where you're going, but go ahead.
Okay. If you chill discovery, then parties will live in fear of this exact type of case, which is that if a litigant is disgruntled with the way the opposing counsel or the adversary is conducting litigation, whether it's related to discovery or any other litigation conduct, they then bring an entirely separate case. And now the adversary's counsel is a defendant. The adversary is a defendant in a separate case. Counsel is disqualified.
I think we have it. Thank you. Mr. Hogan?
Good morning. My name is William Hogan. I represent Peter Coco, and I have nothing further to add.
All right. Thank you. Mr. Marola?
Good morning. Your Honor, in this case, what's really interesting is counsel has brought up some very important points. One of the points was Attorney Caffrey's reply in the case. Attorney Caffrey's reply in the case was that he received the subpoena from the U.S. Attorney's Office for a grand jury investigation. He never stated in his reply who else he gave records to. Also, that grand jury investigation would have been a secret investigation. Therefore, Attorney Caffrey could not have given any information that was subpoenaed by the grand jury to anyone else outside of the grand jury. By the way, that grand jury did not come back with any indictments.
But Mr. Marola, that does not go to the core question under the anti-SLAPP statute of whether the use of that material through discovery and the sharing of that discovery obtained material was protected within the scope of petitioning activity.
Okay, so in regards to the petitioning activity, the petitioning activity does not allow for certain things to occur. Certain things are not considered petitioning activity. The records weren't just disclosed to the parties in this case. Two of the defendants used that information and transferred it to outside parties other than this case. I was not allowed discovery based on the anti-SLAPP statute, which would show text messages and phone records between the parties and from the parties to myself, telling me exactly who they were notifying with this information that was protected under the court order.
Okay, but we're focusing right now on the order that's on appeal and not other
Well, the order,
grievances.
I understand.
The defendants argue that it's undisputed that the bank records used by Attorney Bowers and the Vilma Cataldo summary judgment motion were independently obtained by separate subpoenas issued by Attorney Bowers in the Cataldo case, and that they weren't covered by the court order as to the ex parte subpoena in the OCV case. What do you say to that?
Well, first off, the records that Attorney Bowers used, he used before he sent a subpoena. The records were used twice in court. That's on record in Essex County. Those records were delivered to were presented in court as evidence in a preliminary hearing, and I made a point to explain to the judge in that particular case that there was no subpoena issued. At that point, Attorney Bowers submitted a subpoena days later for the records from Bank of America, but he had already had them in his possession.
But you agree they were independently subpoenable? That's clear.
Well, they would have been independently subpoenaable, except for the fact that Attorney Bowers and Vilma Cataldo received all of the records of Metropolitan Capital Income Fund, and L&M Financial. There were records in there that were under the court order. So they shouldn't have received any of those records until after Attorney Bowers had submitted a subpoena for specific records. Attorney Cataldo stated he took the records and gave them to Attorney Bowers based on the fact that his client, Peter Coco, had those records and gave them to him. That's a fact. That was stated to the Board of Bar Overseers and in an affidavit by Attorney Cataldo in the Vilma Cataldo case. They had the records in their possession prior to any subpoena. But what they did with the information is what caused the emotional distress, financial distress, and actual physical harm to me. That's why Associate Justice Wilkins allowed that third part of my complaint to go forward.
Precisely what acts do you say caused your emotional distress? With specific reference to any act which took place outside of, distinguish between acts which occurred in a courtroom and acts which occurred outside a courtroom.
Okay, for example, I received multiple text messages from defendant Vilma Cataldo telling me that she didn't care what she had to do or who in my family it would affect, but she would destroy me and my family. I received phone calls from Peter Coco to the same effect. My wife received threatening phone calls. We had to have the North Andover police come to my house to investigate those phone calls. My wife also.
Sir, how are those tied? How are those, sir? How are those calls or messages tied specifically to the disclosure of the bank records versus an allegation that you lost a bunch of their money?
They actually referenced the records that they had in their possession to the calls to my wife. Ms. Cataldo actually told my wife she had evidence that I was not only the records that she had, but that I was involved in other matters outside of my marriage. She tried to destroy my marriage.
And let me limit my question here. And for purposes of my question and this appeal, you need to limit yourself to the allegations contained in your complaint, because that's what we have in front of us. And I'm not seeing, I may have missed something, but what you've just said to us does not appear in your complaint. Is that correct? Or have I overlooked something?
I beg to differ. I don't have my complaint in front of me right now, but this conversation actually took place in Justice Wilkins' hearing as well.
But that may be the case. I'm just looking at your complaint, which seems to focus on the disclosure of the documents within the litigation and to the U.S. attorney.
I don't believe I mentioned the disclosure to the U.S. attorney. If it was asked for the U.S. attorney by subpoena, they would have gotten it anyway, and I'm sure they did. It was what went on after. The emotional distress is what went on with the information. to use that information to contact family members, my mother, my father, my sister, my brother, all of that was outside of the petitioning activity.
But I think to Judge Sullivan's point, which allegation of the complaint addresses those activities?
The emotional distress.
No, but I mean, the factual allegations, I'm sorry. I'm reading the complaint and I don't see any reference to those contacts.
Well, I apologize. I don't have the actual complaint with me. So
That's okay. That's okay. We can look at it. You should just know that for purposes of this kind of a motion, we look at the complaint.
I understand.
And I don't mean to minimize in any way the other
Oh,
statements.
no, I don't take it that way, Your Honor. Not at all. But in this particular matter, even Attorney Silva makes note that she thinks that the activities outside of the petitioning should be allowed. And she was asked that question specifically again by Justice Wilkins. And in his response to that motion hearing, he allowed for that third part of the complaint to go forward based on the information that he had in the complaint. So he felt as though I had to be allowed to go forward with that complaint, and in discovery and an amended complaint, I would have been able, in my opinion, to be victorious in that part of it.
Just as a fundamental question, though, you agree that the bank records were subject to subpoena, right?
By the original case in the old Center Ventures case, yes.
Well, but also in the U.S. Attorney's action investigation.
Well, I'm sure they were subject to a subpoena by the U.S. Attorney's investigation, but that investigation took place after my complaint was filed.
Right, but I mean, you would also agree, I take it, that despite in setting aside any question about the specific details, scope, definition of entities in the ex parte order, assuming for purposes of this question that that unauthorized disclosure of the records would violate that order, there would be a necessary exception to respond to the power of subpoena from the U.S. Attorney.
There would be a necessary exception which applied to Attorney Matt Caffrey.
Right. So disclosure of the records in response to a valid subpoena would not violate the order, even if the order otherwise would apply.
I would have to agree with that.
Okay, all right.
I read your complaint, however, to say that the materials were voluntarily disclosed to the U.S. Attorney before the subpoena. Is that what the allegation is?
Yes.
Making that claim?
Yes, I am.
Okay.
This particular case where the attorneys have referenced two other cases, those two other cases were against an LLC. They weren't against Stephen Marola. The old Center Ventures case, they dismissed any case against Stephen Marola immediately upon our request for discovery. As soon as we believe discovery should be had, Stephen Marola suddenly dropped out of that case. When the U.S. Attorney starts there, because I sat with the U.S. Attorney for hours, I disclosed all the information I had. And what I found out based on conversations and based on the fact that we filed a Freedom of Information Act request, things were happening behind the scenes outside of the cases. That's where the emotional distress came. I believe if my count 3 should go forward based on all of those outside activities. I mean, to be investigated by the U.S. Attorney's Office and the FBI for months at a time and 2 grand juries and not a single indictment tells me a lot. They destroyed my business, my family, my
Mr. Marola, I've lost your audio momentarily, and I see others nodding their heads.
I have a glitch.
There you go. We're good.
There, you're back.
I apologize for that one.
All right.
Can we hear each other now?
We can. Is there? I don't want to cut you short. You have 2 minutes left. Is there anything else that we haven't covered that you would like to tell us?
At this point, Your Honor, I think you've covered as much as possible in that you would need in regards to the questions as to what occurred. But the fact that Justice Wilkins.
And we've lost your audio again. No. Yeah.
I lost you there.
There you go. Nope.
You keep going in and out.
We can hear you now.
All right. Quickly, based on the fact that Justice Wilkins deliberated on this thoroughly and decided on that one count that should go forward based on the information that was there and the fact that I should be allowed discovery in that part of it is important, and I think that should go forward.
All right. Well, thank you very much. Of course, it's our task to determine whether Justice Wilkins was correct on the law when he made that determination. But we always extend a great deal of respect to our colleagues on the trial court, and we will give this careful consideration. With that, unless my fellow panelists have any further questions, seeing none, the case is submitted. We are in recess, and we will evaluate the arguments in the case. Thank you all for your presentations.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.